Be seated, please. Gentlemen of the jury, at this stage of our proceedings, after the evidence has been concluded and after the lawyers have had the opportunity to argue the case to you, it becomes my duty to give you the court's charge. By that, I mean I will discuss with you your function here as jurors. I will give you your instructions upon the law of the case and discuss the evidence with you to some extent. The charge in this court is oral. While you may note that I'm speaking from some notes I have before me, the charge is not in writing. You will not have it with you in the jury room, so please give me your careful attention. First, as to your function, gentlemen, when it occurs in the trial of a case that there is a conflict in the evidence, some witnesses testify that it happened in one fashion, and other witnesses testify that it happened in a contrary fashion, or where a determination must be made as to whether there is sufficient evidence to convince you beyond a reasonable doubt of the truth of the charges of the indictment, some agency of the court must consider that testimony, must weigh it, must determine what is true and what is false, and must determine what weight is to be given to it. You gentlemen who compose our trial serve that function. You are the fact-finding arm of this court. In determining what is true and worthy of belief and what is not, we think there are many factors that you will want to consider if a witness looks you in the eye, if he tells a story that tells you there are issues, if it seems to make sense, if it seems reasonable. Those are indications that that person is a credible witness and that his testimony is worthy of belief. On the other hand, if he appears evasive, if the story which he tells does not seem to hold water, as is sometimes the case, if it does not seem consistent with your common sense, we think that these are the indications that testimony should be taken with some reservation.